everyone, myself Hang from Lords of Law Private Limited. Today in this video, we shall discuss the basic sources of law. Now, in order to start with the basic source of law, we need to first understand what actually law means, and then slowly we're gonna proceed about the various sources of law that has been recognized. So let us begin with today's video. Now, for understanding what actually law means, we're gonna state that for a normal layman, law will be as a rule or a regulation. Now, this is not the case, since if I make a rule or if I make a regulation, that won't be qualified as a law. So, in order to qualify it as a law, it is essential that those rules and regulations which are made by a competent authority, or more precisely, which are made by the people or the members of the parliament, will be qualified as law. If we take the account of Austin, according to Austin, law is the command of the sovereign. Now, what does the command of the sovereign stands for? It means that it is the command which the sovereign, that is the head of the state or a person who has the sovereign power to exercise over the people makes, will be qualified as a law. So in simple terms, we can thus define law as those rules and regulations which are made by a specific procedure by the members of the parliament or by competent authority will be qualified as law. Now, moving on to the first basic source of law, that is custom. Now, what is custom? In our day-to-day life, we, especially the Hindus, generally use the concept or the term of custom. That we have this custom, we have that custom, but few of us know what actually a custom is. Now, a custom can be defined as a habitual course of conduct or specific patterns of behavior. If a certain group of persons for a reasonably long period of time observe certain code of conduct or observe certain course of conduct or certain modes of behavior, that will be qualified as the custom. Now, there are several conditions which needs to be fulfilled. Only then a custom can be considered as a valid custom. Now, let us focus on what those conditions are. The first and the foremost thing is that the custom must be of a very long time. What does it mean? That the custom must be antique. It is essential to show that any practice or any pattern of behavior to qualify as a custom, it's necessary to show that that particular behavior has been practiced from a very long time. If you cannot prove the antiquity or the antiqueness of the custom, then that custom won't be considered as a valid custom. Another important condition for a valid custom is that a custom needs to be observed throughout the time. That is, if it so happens that a custom was observed 1,000 years earlier, but gradually it has lost its existence, then in the present day, we cannot call it a valid custom. So, in order to qualify as a valid custom, you need to show that throughout the time period, the custom has been observed by the people. Another important condition is that the custom must be reasonable. Now, we are considering custom as a source of law. If the custom is unreasonable, or if the custom is opposed to public policy, or if the custom in any way is illogical or irrational, there is no explanation or justification as to why we will consider that custom as a valid one. So, in order to qualify as a valid custom and a basic source of law, it is important that the custom needs to be reasonable. Next, the custom needs also to be certain. It is important that there should be certainty in a custom. One of the essential conditions of the custom that I want to highlight here is that any custom, whether it is antique, whether it has been continued for a very long time, whether it is logical, reasonable, whatever be the fact, but it is essential that a custom must not be opposed to any statute in existence. If you practice any custom for a very long time, for example, take the example of sati. Now, sati was a custom which was observed by the Hindus for a very long time, but the sati in the present time cannot be observed since it's opposed to one of the statute, which is a Prevention of the Sati Act 1829. Now, for this reason, it is important that any kind of custom, in order to be qualified as a valid custom, should not be opposed to any statute. Now, coming to the concept as how a custom is considered to be a law. Now, as we Hindus are guided by our principles, our traditions, our custom, so it has been undertaken by the members of the parliament a certain custom, if it qualifies the essentials, as I have already discussed earlier, of a valid custom, then that custom with state recognition will be qualified as a valid law. Now, if we take the example of the Hindu Marriage Act 1955, as per the Hindu Marriage Act, it has been held that the major condition or the major criteria for a couple to be declared as married is Shaptapadi, or taking 7 steps around the fire. Now, this is a custom. This is a custom which has been observed by the Hindus for a very long time, and as regard to that custom, since it's qualifying and since it's fulfilling all the conditions of essential custom, it has qualified as a valid custom, and this custom is ultimately molded into a statute. So in this way, we can consider custom as a basic source of law. Moving on to the second basic source of law, which is the precedent. Now, in a country where the judiciary or the judicial system is so strict and firm, precedent act as an important source of law. This is also to ensure that the judiciary has been given the authority to make the law as well. So, the traditional concept or the traditional perspective that only the members of the parliament is responsible for making the law comes to an end, and we see that another effective organ of the government, that is the judiciary, has also been given the power to make laws. Now, what is precedent? So, it is very obvious that in all the cases, a particular law doesn't apply. The facts and the circumstances actually determines what kind of law should be applied to the case. So, in a given situation, if a law doesn't apply to a particular case, the judges or the competent authorities of the court have the full right to actually mold the law and present or apply it in such a way that the case is resolved and justice is delivered. Now, while doing this activity, the judges formulate certain judgments or certain decisions which are recorded for further use, and that is known as precedent. So, a precedent is something which can be considered a judgment law. These are the judgments or the decision which are passed by the respective judges, and these are recorded for further reference in future use. Now, coming to who can make a precedent. The High Courts and the Supreme Court has been given the power and the authority to formulate precedent. It is important here to know that the decision passed by the High Court is not binding on the other High Courts. However, the decision or the precedent of a High Court shall be binding on all the subordinate courts, whereas the other High Courts have full authority to change or modify the precedent as they like. Consequently, a precedent or a judgment recorded by the Supreme Court shall be binding on all the subordinate courts, including the High Courts of the respective state. But again, it is important for here to know that our Constitution states that a Supreme Court shall not be bounded by the decision of the Supreme Court itself. So, in a present case, if the Supreme Court has made a precedent, subsequently only the Supreme Court has a right to modify or change the precedent. Another thing regarding this source of law precedent is that the precedent, or when a judgment is passed, the precedent is formulated on two essential things: ratio decidendi and obiter dicta. Ratio decidendi, as from the name suggests, is the basic ratio or the principle on which a decision has been passed by the honorable court. Now, what are the legal principle or what are the legal grounds on which a decision is passed by the judge constitutes the concept of ratio decidendi. On the other hand, obiter dicta is anything which the judge has said or written apart from the ratio decidendi. So, obiter dicta stands for the observation made by the judge in dispensing justice or resolving a case which consequently does not involve the ratio decidendi. So, in simple terms, we can say that ratio decidendi is the reason for which a judgment is passed. Obiter dicta is an observation which the judge has done before passing a judgment. So with this we can say that definitely precedent constitutes a very important source of law. Here the judiciary has been given the power to make the law, and these decision or these judgment of the judiciary are of vital importance which are recorded for the future purpose. Moving on to the third and the ultimate basic source of law. Now, in modern times, the ultimate or the third basic source of law is the legislation. It is a very normal thing for the people like a layman, that is people who doesn't know law or is not a law student or from the legal fraternity, that what is law? Law is something made by the parliament. We are electing our representatives. They are sitting in the parliament and they are making the law. This is the concept of this law. This is from where law comes. But in this video, it has been very clear. I hope that it is very clear from you to you guys that it is not only the parliament that makes the law. There are several other sources of law as well. So coming on to this concept that how the legislation can be considered as a source of law. Legislation can be defined as a process by which the legislature makes the law. This is the legislation. So in modern times, in a democratic country, what happens that the people has been given the power to elect their representatives. These representatives, after gaining the majority of the votes, gain seats in the parliament and is responsible for making laws in the parliament by, of course, following certain procedures which are provided in the constitution. Now, coming to this concept that there are two types of legislation basically. One is a supreme legislation and another is a subordinate legislation. What is supreme legislation? As from the name it suggests, supreme legislation means a legislation which is made by the supreme authority or the sovereign authority or someone who has the sovereign power to make the laws. Now, in a country like India, the supreme legislation is vested with the parliament. That is, a parliament is has a top position to make the law, and it is a parliament whose laws are constituted as statutes and followed by the people of the country. Another type of legislation is the subordinate legislation. So in modern times, it is very clear that it is not only the parliament who will be sufficiently making laws for each and every aspect or each and every sphere in the society. There are certain other authorities or there are certain other persons who also should be given the power to make laws for their respective use. Now this thing is known as the subordinate legislation. The subordinate legislation includes the laws made by the municipal corporation, the municipalities, university, colleges, any local authorities, any such thing will be considered as subordinate legislation. Another important aspect of subordinate legislation which I want to highlight here is that delegated legislation. Now, what does delegated legislation means? As I already mentioned that every country now strives to become a welfare country. That is, it strives to do maximum thing which is possible for the welfare of the people, the safety of the people, the protection of the people. A state always strives to take care of every aspect of a person's life, whether it is social, economic, political, cultural, every aspect. In doing so, it will become very problematic for the parliament only to make laws regarding all the aspects. So, it has delegated, that is, it has gifted certain rights. What right or what power? The power to make law to whom? The executive. So, in the present atmosphere or in the present situation, the executive has also been given certain powers to make laws, and that is what is known as the delegated legislation. So in simple term, we can explain delegated legislation as a power delegated by the legislature to the executive to make the law will be considered as delegated legislation. Now, in modern times, we as a law students, we are studying various types of legislations, which includes the Hindu Marriage Act, the Special Marriage Act, then we have our IPC, that is Indian Penal Code, CRPC, the Code of Criminal Procedure, the Code of Civil Procedure, etc., etc. These are all of the statutes which has been passed by the parliament and which actually forms the basic source of law. And the third position, that is legislation. So with these, I conclude today's video. I hope you guys like this video, and most importantly, I hope all of you have gained certain knowledge from this video as well. So in this video, we have discussed what are the basic source of law. Now, one thing which I want to highlight here is that this is the video about the basic sources. There are several other sources of law as well, but the three most important or the three basic source of law is the custom, the precedent, and the legislation. These three we have discussed here, and I'm sure you have find this video informative. Thank you.